David Parker. The Honourable David Parker.
Thank you, Mr Chairman. I rise to take a call. I want to speak both about corrections vote and Attorney General. As my colleague has highlighted, Kelvin Davis, the terrible fiasco which is the Serco contract at the remand prison in Mount Eden is a disgrace. The performance of the Minister has been abysmal, so much so that he really is very aptly called the Minister for Corrections, because I've never seen a minister have to make so many corrections after so many mistakes in the House. Mr Speaker, one of the core responsibilities of the state is if they incarcerate someone and take away their liberty, they should at least protect the person from harm. And the fact that this Minister of Corrections has so woefully overseen the Serco contracts that we have through the television seen assaults, we've seen people who have died as a consequence of their treatment in corrections facility is a woeful indictment of the National Party's conduct of this performance, and it's a failure of their responsibilities to New Zealand. And it is what was predicted would happen with Serco, because the only way they can significantly save cost is to have lower levels of staff and therefore lower levels of supervision of prisoners, and that results in the sorts of debacle that we've seen overseas where they've been severely criticised and in New Zealand. Mr Speaker, I want to talk briefly about the vote Attorney General. Sir, last Friday, Justice Heath in the High Court delivered the first declaration ever under the Bill of Rights Act 1990 for the first time since that Act was passed more than 25 years ago, or 25 years ago this year, a declaration that legislation pushed through this Parliament was in breach of the Bill of Rights. That legislation arbitrarily stripped all prisoners of their right to vote. Mr Speaker, there's not much sympathy in society for prisoners, but as we've seen in the Serco case, they should have some rights. And why the High Court found made this unprecedented declaration of non-compliance with the Bill of Rights is they found that the National Party legislation that was opposed by the Labour Party and other opposition parties, including the Greens in this Parliament, was arbitrary. The effect of it, previously, if you were in prison for more than 3 years, you lost your right to vote. The legislation stripped it from all prisoners and was found to be arbitrary. Why? Well, if you're someone who has decent home circumstances and get home detention, you can vote. But if you're someone from a difficult situation and haven't got anywhere to go, and therefore you don't get home detention and you're put in prison, you don't get the right to vote. That's arbitrary. What else? Well, if you have a 2-year prison sentence and it happens to fall between an election, you get the right to vote. But if your 2-year prison sentence happens to traverse a voting period, you lose the right to vote. Mr Speaker, we sought then an urgent debate on the issue in Parliament because it's difficult to get these issues debated in Parliament because the government is clearly or should be embarrassed about this terrible outcome, and we were refused. And that's within the jurisdiction of the Speaker to refuse that, but it highlights the need for a change to the arrangements in respect to the Bill of Rights. As Andrew Little said in a recent speech, referring to the Labour Party policy at the last election, we think we should adopt the recommendation of the Constitutional Review Panel that says when the courts find legislation to be in breach of fundamental rights, and this is one of the fundamental civil liberties of any democracy, choosing who you are going to have to run the country, those sorts of taking away of rights can change electoral outcomes, as we saw in the presidential election in Florida when they stripped so many people of their voting rights and changed the outcome of the world, given that we had George W. Bush, who then invaded Iraq and led to these terrible problems in part that we've got on the other side of the world. When these sorts of things are identified by the court, they should automatically come back to Parliament and be re-debated. It doesn't mean to say that Parliament should hand over to the courts the right to strike down primary legislation. I don't think we should do that. But I thought that the recommendation of the Constitutional Review Panel for this mid-course, where if a declaration of non-compliance with the Bill of Rights is made, then it should come back to Parliament, be put on the order paper, and the legislation concerned should be re-debated by this Parliament rather than the breach ignored.
Chairman.
The Honourable Amy Adams.
Mr. Chairman,